successful and ethical law practice. A lot of times people think this is somewhat paradoxical, but in reality, as you'll see throughout this presentation, following the rules to have an ethical practice are the very keys that will allow you to be successful. And I hope I'll convince you by the end of the course. Thank you for the great introduction. I'll just tell you a few more words so you know who you're hearing from. I center my practice around representing lawyers and other licensed professionals. I advise them on having successful and ethical practices. And in the worst case scenario, I defend them and help them protect their licenses. And my firm also practices in the areas of business law, real estate, and trust and estates. And I first got into this field when I was clerking for the Departmental Disciplinary Committee for the first department, which is now the Attorney Grievance Committee. Okay, so step one to running a successful law practice, and I'll just say at the outset, this is a 1-hour presentation. We could do a full 2 days on running a successful and ethical law practice, but I'm just giving you, and this is a survey, Spark Notes. One is you got to really pay close attention to your escrow obligations, and you know this. Anytime you go through law school or take the MPRE, you know that your escrow obligations are serious. But it's one of the most serious allegations to be investigated by the Grievance Committee, and it's the #1 reason for suspensions and disbarrals of lawyers. So even if you think you're being careful, it's not enough to just be careful. You really need to make sure that you're following the rules to the letter. It's taken very seriously by courts and grievance committees. And it's especially important for real estate lawyers because real estate lawyers commonly act as escrow agents. It's governed by Rule 1.15 of the Rules of Professional Conduct. And all of the rules of professional conduct that are referenced today will be in your materials. The materials also include some ethics opinions from various bar associations and maybe some case law. We're going to talk about what some of the rules are. We're going to talk about commingling, misappropriation, and record-keeping obligations. What needs to be put in IOLA, other fiduciary obligations, and other sources of law. So just on the topic of IOLA, in New York, if you're if putting escrow money into a non-interest-bearing account, it must be an IOLA account. Any other escrow account that you're holding for where you hold clients' money or property must be interest-bearing. This is state to state. New Jersey has IOLTA. So if you practice in multiple jurisdictions, make sure that you're aware of what those jurisdictional requirements are. So the first thing to talk about this is preserving the identity of funds and commingling funds. So preserving the identity of funds. What that means is for every cent in your escrow account, you need to be able to know whose money that is. And for every transaction you make, you need to be able to go to a record and see who those funds belong to and what the purpose of the transaction is. This is something that is actually a conversation that's occurring in professional responsibility lawyer circles right now about what are appropriate ways to preserve the identities of funds in transactions. Some lawyers will not send wires from their escrow account unless it can have a description as to the identity of the funds. Other lawyers in the field disagree and say that's what the purpose of the ledger is, and we'll get to that later. But just so you know, this is one of those areas where you really want to go above and beyond to make sure that for every transaction, you know whose money is being transferred. That means no debit cards from your escrow account, no using ATMs, and no writing checks to cash. Those are per se violations of the rules of professional conduct. You cannot do it. Commingling is when you funds your personal funds or your office's operational funds with funds that are being held for a client, or holding funds for multiple people without being able to clearly identify who's entitled to what funds. So what that means is if you hold money for clients, you need a separate operating account and an escrow account. If you're a sole practitioner, it's technically permissible to use a personal account as an operating account, but it's usually a good idea to have an operating account for your firm. Well, what do you do with retainer funds? In the day, you used to be required to hold retainer funds in escrow, because the theory was that until you've earned the funds, they're not your funds. Well, New York State has reversed course on this, and New York State Bar Association Formal Opinion 570 is in your materials. And it talks about the reasons why we've changed course on this. Typically, the way New York looks at it, when you're paid a retainer, those are your funds. It's not the client's funds. Yes, you have a responsibility to return unearned portions, but as far as New York law is considered, they're your funds. They do not have to go into an escrow account. One of the reasons why it's advisable not to put retainer money in an escrow account is because you really have to be diligent about withdrawing the funds once they're earned. Because if you don't withdraw the funds once they're earned, then you're commingling your earned fees, which is your money, with potentially other clients' property. So you could accidentally be commingling just by not withdrawing fees as they're earned. It is permissible, however, to keep clients' retainers in escrow. It does feel like a paradox, since we just said you shouldn't keep your own money in an escrow account, and technically retainer funds are your money. But I think that's just a function of the fact that the standard used to be that they be kept in escrow accounts, and want to trip people up by suddenly making it illegal to do so. But the rule is that you're permitted to have retainers in escrow accounts, but it's not recommended. Misappropriation. That's when you one client's money for purposes that were not directed by that client. You might hear the term conversion. What's the difference between conversion and misappropriation? Well, there is no such thing as conversion in the rules of professional conduct. It is a term that's used, and colloquially, the difference is that misappropriation is when you take one client or one third party's funds and use it for another, and conversion is when you take a client or third party's funds and use it for yourself. Let's look at some situations how and when and why this occurs. A lot of times, the biggest reason for misappropriations is for record keeping. If you're not sure how much money you've got left for one client, and you write a check that's bigger than the amount that they have because you don't have proper records. I've dealt with a situation many times where someone will write a check and the attorney will deposit the check into escrow, and they'll write out checks on those funds. But guess what? The check putting the money in the escrow account has not cleared. Maybe there was a stop payment. Maybe there were insufficient funds. Maybe the bank put a hold on it. This happens all the time. You really need to make sure that the funds have cleared, not only just confirmation that the check has been received, but that the amount has cleared until you can write checks on those funds. Does it matter in the eyes of the grievance committee whether it was for personal use or not for personal use? Well, yes and no. It matters in that if you're found guilty of professional misconduct, it may go to the sanction, whether you get a 6-month suspension or a 2-year suspension, or you get disbarred. it can play a role there, but it really doesn't matter in terms of whether or not professional misconduct occurred. If you have misappropriated clients' funds, whether it's for personal use or non-personal use, whether it was accidental or intentional, you have committed professional misconduct. What if you restore the funds? Is that good enough to correct it? Well, no, it's not good enough to correct it. Again, that could be considered in terms of what the sanction should be. But the moment that clients' funds are invaded, that is professional misconduct, and that can't be undone. And clients are considered, and third parties are considered to be hurt even by temporary invasions of their funds and property, even if it's restituted. And you really have to be careful when you're writing checks because if you write a check from an escrow account that bounces, there's a law in New York, the financial institution is obligated to send a report to the Lawyers Fund for Client Protection, and the Lawyers Fund for Client Protection will alert the grievance committee, and they will open an investigation automatically. And the dishonored check overdraft notice rule is in the materials. Record keeping, and I'll just say, I know we're spending a little bit of a disproportionate amount of time on these escrow obligations, but it's really worth spending time over. I'll go a little faster through the other sections because I want to make sure we get into this in detail. You have to keep 7 years retention of records. Ordinarily, attorneys think that they have to keep all client records for 7 years. There actually is no hard and fast rule about keeping clients' files. The 7-year rule regards to escrow records. Got to keep a contemporaneous ledger. That means the very moment that you make the transaction, you got to write it down in your ledger. It's not the next day, not not that night. You got to do it right when you're making the transaction, because sometimes you're making multiple transactions in a day, and you have to know how much funds are remaining. The ledger needs to clearly identify the ownership of the funds. It should show the balance of each client or third party's funds in your escrow account. It's your best tool against accidental misappropriation. If you've got contemporaneous master ledger that includes all the funds you're holding for clients, it's a lot harder to screw up. We talked about this a little bit before. If you're using a non-interest bearing account, you have to use IOLA. What if you are using an interest bearing account? Is there any obligation to use an interest bearing account? The State Bar took a look at this and the opinions in your materials. It depends on the size of the funds and the length of time. If you're holding millions of dollars for several years, then you probably have an obligation funds in an interest-bearing account, because it's actively hurting the client or the third party if these funds are not gaining interest. But if it's a small amount of money for a small amount of time, you're fine using an IOLA account. And the best practice is to recommend that the parties give specific instructions in the escrow agreement, because as long as you're following the parties' instructions, you're not going to run afoul of these types of rules. There are some other sources of escrow law. There's a list of approved banking institutions published by the New York Lawyers Fund for Client Protection, and the rules for the IOLA program, which are also included in your materials. Let's move on to number two, the number two way to run a successful law practice. And we're going to talk about tips and obligations for law firm management and supervision. Law firm manager or supervisor is an engagement agreement. And this is regulated by Section 1215 of the New York Code. And engagement agreements are not always required, but they are always a best practice. Not required. I always advise my clients to use engagement agreements for each and every matter. They're very helpful because they limit the scope of the representation, so you're not on the hook for a matter that's dragging on and dealing and experiencing mission creep, especially if it's a flat fee. It also sets expectations between you and the client for what the fees are going to be, communication expectations, and responsibilities of you and responsibilities of the client. And if there are any questions later on as to whether you've acted in line with the client's instructions and expectations, your engagement agreement, if you thought ahead, can resolve those issues. So when an engagement agreement is required, it must at the very least explain the scope of services. It must explain the fees that your firm is going to charge. It explains how you're going to deal with expenses, what your billing practices are. And in some cases, in most cases nowadays, the right to arbitrate fee disputes under Part 137. That said, advising clients of their right to arbitration under Part 137 is not enough for you as the lawyer to invoke that right. It's enough for the client to invoke that right. But if you, the lawyer, wants to arbitrate a fee dispute, there is other specific language that you must use. And I believe I've included an article in the materials that includes the language that's suggested by the Part 137 fee dispute program to include in your engagement agreements if you would like to avail yourselves of that program. Engagement agreements are not required if the fee for the engagement is expected to be lower than $3,000. It's not required if you're representing the same client that you've represented in the past in a manner similarly to which you've represented them in the past on a similar type of matter. It's not required if it's a domestic relations matter, which is subject to Part 1400, which has its own separate requirements. And it's not required under New York law anyway, if it's not a New York representation and has essentially no nexus to New York. But like I said, it's really to your benefit to do it, even if you don't have to. So let's talk about supervision of subordinate lawyers and non-legal professionals. Part of running a law practice is running a business, and many lawyers who run a law practice have people who work with them. And lawyers with management responsibility, and when we say that, we're usually talking about partners, but it could be anyone who has management responsibility. It could be a senior associate who's responsible for supervising others. They have an obligation to make a reasonable effort to ensure that other lawyers in the firm abide by the rules of professional conduct. And they have to supervise the work of other lawyers. How do you supervise other lawyers' work? What degree of supervision is necessary? This is, the rules of professional conduct are littered with the word reasonable. And as you know, it's what's reasonable for one person is not always reasonable for another person. So there is some gray area, but it does give you hints as to what you should consider in determining what level of supervision is necessary. Consider the experience level of the subordinate lawyer, not only as a lawyer, but also in the practice area. Let's say you're hiring a 7-year associate who's spent 7 years doing M&A at a big law firm. They've got great credentials. They were at a great firm. They've got 7 years of experience, but they've never done real estate work before. And you're hiring them to do real estate work. You're going to have to supervise them like they're a fresh lawyer, not like they're a 7-year professional. Maybe not exactly, but you've got to consider the level of experience in the field and make sure that their work is properly supervised and that they have the resources they need to be able to do the work properly. You can consider the amount of work involved in the matter that they're handling. And you can also consider the likelihood that ethical problems will arise throughout the representation. Well, the next question that should come to your mind is, well, if it's my obligation to supervise them, when do I become responsible for their conduct? Can I be held responsible for their conduct? Similar to respondeat superior. Supervising lawyers can be responsible for the misconduct of subordinate lawyers in several situations. Supervising lawyer is responsible for the subordinate lawyer's conduct if they order the subordinate lawyer to engage in the conduct, or if they direct it, or after they find out about it, if they ratify the conduct and say it's okay. Another way that a supervising lawyer can be responsible for a subordinate lawyer's conduct is if they are aware of the subordinate lawyer's conduct and they don't take reasonable preventative or remedial action if they have the opportunity to do so. So look, if an associate is conducting an elaborate scheme to steal money from clients, let's say, and they cross all the T's, dot the I's, leave no stones unturned to make sure that it can't be detected, and you don't detect it, you're probably not going to be held responsible under the rules of professional conduct. But if you are checking the books and supervising them like you should be, and you see a discrepancy, and you don't do anything about it, if you don't prevent them from taking the action or do something to fix it once you find out, then you'll be held responsible. And if you don't know, but you should have known in the exercise of reasonable management authority that a subordinate lawyer's conduct is improper, then you can be held responsible as if you did know. What about non-legal professionals? What about supervision of not just associates, but paralegals, law clerks, office managers, secretaries, receptionists? Well, it's the same exact factors, first of all, in terms of whether you're held responsible for their conduct. It's the same exact factors as with associates, but you've got to pay special attention because non-legal professionals can also engage in the unauthorized practice of law, which is something you don't have to worry about as much with associates. And anyone who is not a lawyer who engages in the practice of law is breaking the law. Judiciary Law 478 and Rule 5.5 of the Rules of Professional Conduct are in your materials. And as we just discussed, if you know or should know they're engaging in the unauthorized practice of law, then you're responsible for their conduct if you don't do anything to prevent or mitigate it. So you've really got to watch out for that. A lot of people ask the question, well, what is the practice of law? We would think it would be an easy question to answer as a lawyer, but it's really not as easy to answer as you think. Back in the 60s, there was a big case, Dacey versus New York County Lawyers Association. And this guy, Dacey, published a book, something like Handle Your Own Estate Planning, where it was forms and instructions to fill out so people could buy the book, write their own wills and power of attorney, and do it without a lawyer. And New York County Lawyers Association sued, saying that by publishing this book, the publisher was engaging in the unauthorized practice of law. And the appellate division agreed with them. Or the Court of Appeals, I believe, actually agreed with them, but this went up to the Second Circuit, who reversed. And the reasoning that the book did not interpret the facts and give it particularized advice to specific clients, it was not practicing law. It was rather giving general advice, sort of like I'm doing in a CLE right now. I'm not practicing law because I'm not giving advice to particular clients. I'm teaching general principles of law. There are other factors to consider, but I think that was a pretty interesting case, and it's a good rule to consider whether what someone's doing is the practice of law or not. Also, just a lot of times you'll have paralegals working on forms. One distinction is filling in forms, populating forms based on information provided by a client is not considered the practice of law, but creating a form involves legal knowledge. You have to know what information is required and what the implication of putting that information is. So if you're having paralegal prepare a form and it's not being overseen by you and you're not having the final sign off on what the content of the form is, that could be the unauthorized practice of law. So you got to watch out for that. Let's move on to the third topic, which is referrals, fee sharing, and other considerations regarding non-legal professionals. Before we move on, actually, I see there's a question about an engagement agreement. Let's take a look. Elise asks, in an engagement agreement with an hourly amount, please comment on putting in language that you asked our firm to be your counsel for specific matters that you may refer to us from time to time, including X specific matter. If I don't put this from time to time language in the engagement agreement, do I need a new engagement letter for each matter when the same client comes back to me for a different matter? Thanks. That is a good question. I know that's a common way of writing engagement agreements. I would advise that you have some kind of an out for yourself, as want to make sure that you can withdraw if need be, or if you don't want to continue working on future cases, that you have that escape valve to do that. But if you're working with a client on a repeat basis with on a similar matter, you are not required to enter into a new engagement agreement, even if your first agreement does not include that from time to time language. However, I generally advise that it's a good idea to do a engagement letter for each matter, just to help limit that scope of engagement and set expectations. I hope that answered your question. Steve, I'll try and speak up a little bit, and hopefully you can hear me better. Okay. Referrals, fee sharing, and non-legal professionals. Let's talk about division of fees. This is governed by Rule 1.5 of the Rules of Professional Conduct. It's common for lots of attorneys to work with other types of professionals, legal and non-legal, and especially common for real estate attorneys. We often work with architects and engineers. We work with title companies. We work with brokers. So, real estate attorneys have really more contact with non-legal professionals than many other types of attorneys. We're going to talk about what those relationships can and should look like. You divide fees with other lawyers. I think most of you probably know that this is acceptable, but it's subject to specific rules. When you divide a fee, a legal fee, with another lawyer, it either has to be the division is in proportion to the services performed, or by a writing given to the client, each lawyer assumes joint responsibility for the representation. Really what that means is even if one lawyer is doing all the work, the other lawyer is held responsible for the conduct and held responsible for the matter. They can be sued for malpractice. They can they're held to all the same obligations under the rules of professional conduct. So if there is no writing given to the client regarding this assumption of joint responsibility, you can't share fees if you're not other than in proportion to the services performed. So make sure that you are sharing fees with a lawyer, that the proper disclosures are given. In addition to that, the client has to agree to the division of fees after being given full disclosure of it, and this is confirmed in writing. And on top of that, the total fee cannot be excessive. So you have to have all three of those factors before you can share a fee with another lawyer. What about for referring matters and not both working? Well, that's dealt with the exact same way. When you refer a case and you're getting a referral fee, really you are assuming joint responsibility for the representation, and that's the language that needs to be included. How do you divide fees with another professional, a non-lawyer? Well, that's a trick question. You don't. It's never allowed. Lise is asking another question. I heard that you can take on a matter from another state if it is a very small, minor part of your practice, even if you are not licensed in that state. Is that accurate? Of course, you'd need to be comfortable with your knowledge of that state's law. Is entirely governed by that state's law. New York's New York's rules have no authority and do not purport to regulate conduct of the practice of other states' laws. So I really can't speak on that as we're just discussing New York law today. Just as a quick aside, New York has recently amended its judiciary law regarding people who reside in New York but are not New York lawyers. Well, it used to be there used to be a prohibition. Now there are circumstances where you can practice out of your home in New York. Let's say you're only licensed in Maryland, but you live in New York. Under New York law, you're now permitted to practice Maryland law in New York without a New York law license, but there's a number of requirements that have to be met to be able to do that, and hadn't prepared to include that in today's presentation, but your question reminded me of that, and I wanted to put it in as an aside. Relationships with non-legal professionals. So you can't share fees with non-legal professionals. What can you do with them? Multidisciplinary practices are forbidden. So you can't be, I couldn't have Randy Tesser's law office and accounting firm, even if I was a CPA as well. It would have to be separate businesses. The rationale for that is they think it challenges the integrity of legal profession and could create a conflict of interest. You know, the legal advice that you give someone may not be the same as the investment or the accounting advice. There may be conflicts. In some cases, you can form an organization to perform joint services between legal and non-legal professions, but that's it's really complicated, and we can't get into it at all because it would take up the whole presentation. But if this is something that you're curious about, maybe we'll do another presentation on that topic, or you can consult a professional responsibility lawyer. Lawyers may refer clients to non-legal professionals and vice versa, pursuant to a contractual relationship. This is what's called a non-exclusive reciprocal referral agreement. Essentially, you can enter into a contract with a non-legal professional to refer clients to each other, but it can't be exclusive, and it cannot be for money or property. It says it's number 4, but it really could be number 1. And your biggest defense against getting a grievance to the grievance committee is to communicate. In some cases, it's an obligation, but in all cases, it's a best practice. Communication is the #1 cause of complaints to grievance committees. I'll give you 3 sentences that can protect you from complaints. Sentence 1, I received your email. Sentence 2, I'm having a busy week. Sentence 3, I'll get back to you on Tuesday, or whenever you can realistically deal with their matter. Forgive a lot, even if you make a mistake. You communicate with them and you treat them with respect. On the other hand, even if you're doing a great job and fulfilling all your obligations on time, even early, if the client doesn't know about it, they don't see all that work you're doing, and it's still going to hurt the relationship, even if you're doing a great job otherwise. And this is governed by Rule 1.4, and which sets forth a number of responsibilities where you're required to communicate with your client. A couple of those are if there's information that's required by a court rule or other law to be communicated, any decision or circumstance with respect to which the client's informed consent is required, and that's defined in the rules. But when we say informed consent, it generally means that the client fully understands and has had an opportunity to ask questions and be explained the decision that they're making, and that the decision is confirmed in writing. And about material developments in the matter. What is a material development? Well, it's really any time that you would where the client would have to make a decision. As a general rule, or as a hardline rule, actually, settlement offers and plea offers are always material developments in a case. Even if you think it's so low and insulting that your client would never agree to it, you're always required to communicate a settlement or plea offer to your client. You have to reasonably consult with the client about the means by which their objectives are to be accomplished. You don't, every case have to follow your client's preferences about the means by which the objectives are to be accomplished, but you do have to be in pursuit of your client's objectives and reasonably consult with them. And we'll talk a little bit more about that on the next couple of slides. You have to keep the client reasonably informed about the status of the matter, promptly comply with the client's reasonable request for information, and consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance that's not permitted by these rules or other laws. So if your client is asking you to do something that's illegal, or that you're unable to do for one reason or another, you have to communicate that to your client. You can't just not do it without explaining so. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Go into some detail. What happens if your client's calling 3 times a day? Do you have to pick up the phone every time? Do you have to answer 20 emails in a row? Well, no, you don't have to engage in excessive communication if that's what your client is demanding, but you do have to engage in reasonable communication. So what do? My advice is to set expectations with the client. You could do this in your engagement agreement if you want, but you can also do it after the fact. Establish a policy and stick to it. A client who's calling you 3 times a day, you can tell them, listen, I have a busy practice, but I'm going to make sure that I keep in regular contact with you. I check my emails or I return phone calls at 4 p.m. or on at least once a week, at least every couple of days, and set that expectation. And when you establish the policy, you stick to it. So you don't have to answer every single time your client calls or respond to every single email, but you do need to communicate to comply with the rules that we went over on the last slide. Take good notes, particularly if your conversations with problem clients, and keep good records, because you're going to want to be able to back up that you've established these policies and that you're engaging in reasonable communication with them if this ever gets before a grievance committee. Diana, would this be a good time for me to give the code?
That's a perfect time.
Okay. The code is JOUST. JOUS. Like fighting on horses. JOUST. JOUST. Let's talk a little bit about allocation of authority between lawyer and client. This is very closely related to communication because this is talking about who makes the decisions, the lawyer or the client, and you can't make these, you can't make those decisions without communicating with one another. Governed by rules 1.2 and 1.4, and the general rule is that clients control the objectives, whereas lawyers control tactics. So the client can say, I want you to get me alimony. And you can't decide on your own that, no, they don't actually want alimony, they want custody. That's more important. No, the client controls the objectives. But the lawyer is control of the tactics that you use to achieve those objectives. So let's say client, the opposing counsel requests an adjournment of time to answer some type of pleading, and your client says, no, don't grant them any adjournments. I don't want to give them any courtesies. But in your professional expectation, you know that this judge that you're before has lashed out at lawyers and parties for not giving regular professional courtesies. So you know that it would actually be against the client's interest if you don't grant an adjournment to the other side. It's well within your professional judgment to make that determination. And as we discussed before, you should consult your client as to these decisions. But ultimately, as the lawyer, as the professional, you have discretion to make those types of choices. Communication always does help to resolve these gray areas, though. Include in the materials Rule 1.4, and comment 3 talks, which is the commentary of the New York State Bar Association, talks about the split-second decisions that lawyers have to make. Lawyers don't have to consult a client for every little decision they make during the trial, especially, and otherwise throughout the course of a representation. But they're on the side of caution, because that word reasonable is not interpreted by everyone the same way. And if you've got the time and you think that there's any chance that this is a type of decision that the client should be consulted on, you should consult with the client. But the rules acknowledge that the reality of lawyering is sometimes you have to make decisions at trial, sometimes you have to make decisions quickly, and there is latitude for you to do that, able to do so. Rule states that a lawyer may exercise professional judgment to waive or fail to assert a right or position of the client, or accede to reasonable requests of opposing counsel when doing so does not prejudice the rights of the client. That's what we talked about. A lawyer may refuse to aid or participate in conduct that the lawyer believes to be unlawful, even though there is some support for an argument that the conduct is legal. So if you know the client is asking you to do something that's illegal, you cannot do it, and you must communicate to the client that it's illegal and that you cannot do that. But if you even believe that the conduct that the client is asking you to do is unlawful, even if the client or someone else argues, or you can come up with a good faith argument that it may be supported, this is some discretion that you have. You're permitted to abstain from that conduct if you believe that it's unlawful, even if it may not be. I just want to go back to communication a little bit more because I remembered another important point. Another good way to deal with a client who calls you or emails you too much is to send them a bill. Of course, this doesn't work for flat fee arrangements. That's another reason why defining the scope of representation in an engagement agreement is important. But if you've got a client sending you 20, 30, 40 emails a day, and it does happen, or getting 3, 4, 5, 6 phone calls a day, the bills are going to add up. And sometimes it's a good idea to send the client an email saying, I'm sending you a preliminary bill because this month's going to be higher than you expect, and explain that every time you answer a phone call, every time you answer an email, it takes more time, and you can communicate with your client and set expectations and work with them on strategies that will streamline and make more effective communication between you. In the best case scenario, it'll usually go one way or the other. You'll either have a healthier, more effective method of communication, or if they're a problem client, you might get rid of them, which is sometimes what you want to do. The last topic I want to talk about is not something that is spelled out in the rules, but I think it's just as important, if not more. And that's that you have to take care of yourself. Lawyers, before we do this, I see there's another question that I'll try and get to. What if Judith asks, what if you are dealing with a third party who your client consults behind your back, or one that your client wants with them during your meetings with the client? Short of getting rid of the client, what do you do? Well, that depends on who the party is, what the purpose is. If the client being there confidentiality or privilege, that's something that the client needs to understand. If they're dealing with another lawyer or advisor, that's permitted. They're permitted to get second opinions or take advice of whoever they want. That may indicate that there's a lack of trust between the attorney and the client. And I don't have the time to go into all the different situations you could encounter like this, but the short answer, your client, if there's a problem with trust between attorney and client, you can try and work that out, or maybe the representation isn't working. And keep good records, keep good notes of what you've advised your client when your client tells you they've consulted with someone else who's given contrary advice, or different advice. Make a memo to file, put something in writing to your client, to make sure that your advice is documented, especially when it may conflict with another advisor's advice. It's the clients. Sometimes the clients have to make their own choices, and we advise them the best we can, and we make sure we've documented that we've done our jobs. But sometimes the clients are going to make decisions that we don't recommend. Sometimes that's okay, and sometimes it rises to the level that we need to withdraw. Evans asks a question: would the consultant lawyer have an ethical obligation in constantly communicating with a retained client? That depends on whether they've been retained. You can retain 2 lawyers to handle the same matter. They could work together. If you're going to do that, I would recommend that the lawyers coordinate and try and do it in such a way that you're not stepping on each other's toes. But whether a consulted lawyer who's not the lawyer has these duties under the rules of professional conduct, it depends on whether they're considered to be retained. And that, that doesn't necessarily mean they've signed an engagement agreement, but you'd have to look at whether they've communicated or the client expects that they're going to act as their lawyer. So I do want to move on in the last few minutes to taking care of yourself, which I set up. Why do we become lawyers? Is it for money, influence, power? Well, maybe a little bit, but the vast majority of lawyers I speak to become lawyers because they want to help people, because they want to make a difference. And there are plenty of lawyers who run afoul of the rules at one point or another in their career. And who are these people who are breaking ethics rules? Bad people? Maybe. Are they crooks? Sometimes. Are they former mayors? Sometimes. Primarily sole practitioners. When attorneys, in my experience, most of the times the attorneys break rules, it's not because they intend to, it's not because they're bad people, it's not even because they're bad lawyers. It's because they're good people under stress. And I say most of my clients are sole practitioners or small firms, not because they're worse lawyers, not because they're not as smart, not because they're not as careful, but because big firms and larger firms often have institutional protections and safeguards. They have funds to double check work. They've got often internal compliance departments that sole practitioners and small firms simply don't have. And as sole practitioners and small firms, it doesn't give us an excuse. It's a warning that we need to develop procedures ourselves to make sure that we're complying with the rules. And as I mentioned, we're also susceptible to stress. What kind of stresses can lead to situations where people break the rules? Well, here are some common stressors that I deal with in my practice with my clients. Sometimes drugs, sometimes alcohol, family problems like divorce or a family's illness, or fights with family. If you're working too much, you're not getting enough sleep, you have too many cases, you have organizational problems where you feel overwhelmed by the work that you have. And these are all reasons that good people, well-meaning people, can slip up and make mistakes and break the rules and get in trouble. So what can you do if you find yourself in this situation? Well, there's no easy answer, but I will give you some suggestions. Try and manage your stresses problems as best you can. Don't bottle it up. Talk to your family, talk to your friends, talk to your community leaders and your faith leaders, because they can help you and they're here for you. Whatever it is that you do to manage your stress, and this will be different for every one of you. If you like to go running or swimming or doing yoga or singing or dancing or playing video games, whatever it is that you do it. A lot of times when people are going through a lot of stress, they'll say, let's say I swim every morning and I've got a tough case and I'm not, and this and that and the other's happening. I'll say, well, I'm just going to skip swimming today because I've got too much to do. And granted, if you've got work to do on a deadline, you have to do it. But just because you're stressed, you shouldn't put off your hobbies, because those are the things that you do to manage your stress. It's counterintuitive. You need to keep doing your comfort activities that actually bring you comfort when you need it most. I also encourage you, if you're struggling, to avail yourself of the Lawyers Assistance Programs. They're excellent programs that are sponsored by, there's one by the State Bar, there's one by New York City Bar. And they're excellent programs to help health support to attorneys who are dealing with drug or alcohol addiction or other mental health issues. It's an excellent resource that you should take advantage of if you think it could help you. And also, if you do slip up, if if you have these kinds of issues that are contributing factors and you're actually doing something about it, that's a factor that's considered in mitigation. So it's not only good for you, but it'll also help you before the grievance committee. And lastly, when asking for help, sooner is always better than later. And this applies to all situations. It applies to protecting your mental health and responding to a grievance. Follow the advice I gave you to avoid complaints in the first place. But once they are filed, you should act fast and respond appropriately. Whether it's me or someone else, you should consult a professional responsibility lawyer. There's always say to other doctors they shouldn't perform your own surgery. And when your own license is in jeopardy, you should go to a professional who deals with that to make sure that your license and the way that you earn your livelihood is going to be protected. I encourage you to keep in touch. My contact information is displayed on the screen. And if you have any ethics questions that you want to run by me, feel free to send me an email or give me a call. I'm happy to have a chat with you. And I just want to thank Diana, Richard, and Judicial Title for having me back. I had a great time.
Thank you. Do we have 5 minutes for just a few questions?
I'm fine. Sure.
Okay. We'll just go 5 minutes just so we can end pretty much on time. First question is, what is the firm partner's liability if one of the other partners is misusing escrow funds?
Sure. So as a partner, you do have responsibility for what your firm does. It's not to the same level of supervision that would be expected of a subordinate lawyer, but if you know about it, or if in the exercise of managerial discretion you should know about it, you could be held responsible. I don't want to, I can't. This is really something that will depend on specifics and be on a case-by-case basis, so I can't give you a hard and fast rule, but generally speaking, it's not the same level of supervisory responsibility as when you're dealing with an associate, but you're not completely off the hook either.
Okay. If a bank makes an error, can you be held liable for their error, even if it was not your fault?
Typically, no. In fact, when I assume the question may be referring to the dishonored check notices sent to the Lawyers Fund for Client Protection. In fact, there's a rule built in that in some cases, a letter from the bank explaining error can be submitted to the grievance committee in lieu of a response to the grievance committee's complaint. And in some cases, if the bank can correct its error fast enough, it may not even make its way to the grievance committee. Instead, error, and you could have taken corrective action, and there are things that if you let the bank error sit and don't take actions that you need to in the regular course of representation, may end up becoming responsible and breaking the rules yourself.
Okay. Some real estate attorneys will agree for a client to send funds to the attorney's escrow account, and then the attorney will use the funds to pay the down payment under a contract of sale on behalf of the client, or to pay the balance of the purchase.
I'm sorry, Diana. Can you start that over?
I'm sorry. During a real estate transaction, is paying a down payment or paying off the purchase price proper use of an escrow account?
Yeah, 100%. A down payment should always go into an escrow account. A down payment, let's say you're representing the sellers and the buyers give you a down payment to hold, that is the seller's money. It's not your money. So that if the down payment is going to an attorney, it should always go into an escrow account. And when you're paying expenses out of the down payment, that is, it's pursuant to the client's expectations and instructions. So that is authorized use of escrow funds. That's correct.
One last question, and then we will end because we're just about 2-3 minutes over. You mentioned attorneys that are admitted out of state but live in New York and being able to practice out of their homes. Does that mean that they can practice New York law or only in the state they are admitted?
Good question. They cannot practice New York law and cannot hold themselves out as practicing New York law. They can only practice the law of the state they're admitted in, but they can do it from their home in New York if they follow the requirements that were imposed by the Court of Appeals, and if that is permitted by the state that they're admitted in, because they also have to consider those rules. I see someone in the chat just asked whether the rules regarding division of fees applies to all lawyers or just real estate lawyers. It applies to all lawyers. No lawyers can divide their fees with non-legal professionals, and the rules regarding splitting fees between attorneys apply over all types of practice. I just singled out real estate attorneys because it's fairly common to work with non-legal professionals in those cases.
All right. Well, thank you so much for a great presentation. Thank you for your time. We enjoyed having you. Everyone, I will resend all the material before the end of the day, so in case anyone missed it. And thank you all for attending, and I want everyone to have a very happy holiday and happy new year, and we'll catch you back in January. Thank you.
Thank you, everyone. Happy holidays.